If you're buying a property using subject to financing, where you're taking over someone else's mortgage, there's one thing that can quietly destroy your deal: a letter you never saw. Because in a subject to deal, the mortgage actually stays in the seller's name. So when the lender sends updates, new payment amounts, escrow changes, new addresses, guess who gets them? Not you. I'm Jeff Hampton, owner of STR Law Guys, asset protection and real estate attorney, and author of the best-selling book, Investor's Blueprint: Asset Protection Made Simple. In today's video, I'm going to show you how to make sure you don't become a victim of the letter you never saw coming. We'll break it down line by line so that you can copy and paste this into your next subject to financing contract. Oh, and stick around to the end of this video because I'll also show you what happens if you don't include this clause and how bad it can really get. So I've talked to real estate attorneys, reviewed deals that have gone wrong, and helped investors using subject to financing unwind bad deals that all could have been prevented with just one sentence in their contract. But before we get to that one sentence, we have to remember why subject to deals are so powerful, but they're very fragile legally. Let's first start with why investors love subject to deals. They love them, and I don't blame them because I do too. Subject to financing allows you to take over a seller's mortgage without having to get a new loan. You get the deed, but the seller keeps the loan. The ultimate reason why you would do it is you're buying property with someone else's financing, likely at a much lower rate you could get on the market right now. This is huge if you're trying to build a short-term rental portfolio or you're flipping creatively. You bypass traditional lending, you use less capital, and presumably you're able to make profit from day one. But that also means the bank doesn't even know you exist. So when the lender needs to send an escrow notice or a payment change or the notice that they've actually sold the loan entirely, who do they send the letter to? Not you. This is the ticking time bomb inside all subject to deals. On paper, it totally works, but in practice, it doesn't work unless the seller tells you everything they are receiving from the lender at all times. And if they don't tell you, the ticking time bomb explodes. Which brings me to how buyers of a subject to deal can end up defaulting on the loan without even realizing it. Let me show you how easy it is to default as a buyer on a subject to deal without even knowing about it. You've signed the deal now, you agree to take over the mortgage payments, and now you've actually got tenants in the property. But then something shifts. Maybe the escrow payment changes because property taxes went up. The lender sends a notice, but remember it's to the seller, not you. But you just keep paying the same amount because you don't know any better. Unfortunately, you're now short on your payment by $50 a month. It might seem minor, but technically you are now in breach on your loan. Or what if the loan gets transferred to a new servicer? And by the way, this happens all the time. Let's say Bank A sells the servicing rights to Bank B. They send out a notice, again to the seller, but you keep sending payments to the old address. Now your payments aren't being credited. The loan now shows to be delinquent, and the seller panics and calls default. And in some cases, they actually now have the right to take the house back. But you as the buyer did nothing wrong except trust that the seller would pass this message along to you. But legally, because you didn't know what you didn't know, the seller didn't have to tell you this information, and so now you're still sitting in default, and you're still the one holding the bag. This isn't just theory. There are real cases all over the country where this has happened, and this is where subject to deals fall apart. So here's how to stop that from ever happening by inserting one clause into your subject to purchase agreement. It's called the lender notification clause. Most investors don't include this, and many of them don't even know what it is. They'll insert something like a cooperation clause thinking that will cover them. That doesn't work legally, and you need something explicit that is legally binding so that you are protected. Here's the big point I'm going to give you, what it needs to say line by line to protect yourself. And it needs to say, quote, seller agrees to promptly forward to buyer any and all written or electronic notices received from any lender or loan servicer regarding the existing mortgage or mortgages on the property, including but not limited to payment changes, escrow reanalysis, default or delinquency notices, change of servicer or address, any similar communication. Then you lock it in with this. Quote, seller shall forward such notices to buyer within 2 business days of receipt via email and certified mail. Failure to deliver such notices will be considered a material breach of this agreement. And finally, the protection. Quote, if buyer fails to make timely or corrected payments as a result of seller's failure to notify, buyer shall not be deemed in default, and seller's failure shall constitute grounds for contract termination or legal remedy by buyer. Now, always research your state laws before you move forward with any type of legal action, but this is the shield that provides you actual legal protection. It puts the responsibility back on that seller to inform you as the buyer of any material change on a subject to transaction. It protects you from the hidden legal landmines, and it forces clarity from the seller at all times. But let's wrap up this video by talking about what happens if you leave that specific clause out of your subject to purchase agreement. Now, the seller can just purely hold you hostage. Let's say they get a notice from the bank saying that payments have increased because of an increase in property taxes. They can just not tell you about it. You just keep paying your old payment, but it's completely up to them whether they inform you of anything that could put you in breach of that agreement. The seller could technically wait 30 days and then claim now you're in default. If your subject to deal has a forfeiture clause in it, they might actually be able to legally repossess the property and did so intentionally. Imagine this. You've made 6 months in payments. You've put tenants in the property. You've done renovations. Maybe you've built up $40,000 in equity. But suddenly you lose it all because the seller didn't forward you one email. Or worse, they intentionally chose not to forward it to you because they wanted to get the property back. Without using this clause, the seller can actually exploit you acting in good faith. They might be waiting for you to slip up and then choose to kill the deal, and then use the forfeiture clause to grab the property back from you, and now you've lost everything you've invested into the deal. This clause closes that loophole permanently. Now, finally, let me give you a few extra layers of protection for your subject to deal, and we'll wrap things up. Number 1, always use a third-party authorization form. Get the seller to sign this so you can talk directly to the lender. You won't be able to make changes, but you can check balances, payment amounts, and escrow adjustments. Do this every 90 days. Step number 2, escrow or servicing setup. Use a third-party escrow or loan servicer. They collect your payment, forward it to the bank, and notify you of changes. This adds a neutral record keeper. Step number 3, mailing address updates. Some lenders will send statements to a new address, even if the name on file doesn't change. Get the seller to request this in writing. Step number 4, insurance control. You're the owner now. Make sure the insurance policy names your entity as insured and the lender as mortgagee. Otherwise, a cancellation could trigger forced place insurance, raising the payment and putting you in default again. All these steps reduce your dependence on that seller. Look, subject to deals are a powerful tool for real estate, but only if you have the right legal framework in place. Otherwise, they become very risky and you could lose everything. Speaking of losing everything, what if the seller now, instead of informing you of any changes to the loan, what if he decides he's going to file bankruptcy? Check out this next video. I'm going to break down exactly how to protect yourself if the seller in a subject to financing deal files for bankruptcy so that you aren't the one that pays the price. See you over there.